our Law and Justice segment tonight, guilty until proven innocent. That is the policy President Obama forced on college campuses when it came to sexual assault allegations. Instead of following the rule of law, college tribunals would routinely expel students and therefore destroy lives without due process. Make no mistake, sexual assault is a serious issue, which is why it is all the more important that accusations are handled by the criminal justice system and not college bureaucrats. And now, thanks to Education Secretary Betsy DeVos, who rescinded Obama's backwards Title IX sexual harassment guidelines, there is hope for both victims of sexual abuse on campus and students who are falsely accused. With me now to break it down, attorney and spokesperson for Stop Abusive and Violent Environments, Michelle Owens. Michelle, good to see you.
Thank you for having me.
All right, Michelle, I want to break this down because I feel like there's a lot of false narratives that are surrounding Education Secretary Betsy DeVos rescinding these guidelines that were issued by the Obama administration. So let me start with this question. If sexual assault on campus is so important, and of course it is, why do colleges use tribunals instead of referring directly to the justice system?
Well, I think there's one big reason, and it's because they don't want the reputation and the statistics to get out there of what is going on their college campus. There is something called the Clery Act that every institution that receives federal funding is required to report the number of statistics of rapes, assaults, and so forth. And I think, quite frankly, they don't want the information to be out there.
Right, so essentially these colleges are victimizing students, both students who have been sexually assaulted and those who have been accused of sexual assault. They're victimizing just to protect their own reputation. That is absolutely disgusting. The other part of this, and I think we should start out with what's wrong with the Obama administration's interpretation of Title IX, and that is shifting the burden of proof just to preponderance of evidence. I mean, that's not the standard of proof in any actual in our criminal justice system. That's something that we made up for college campuses.
Right, and there's so much wrong with this. It would take a really long time for us to talk about every single thing that is not right, but that thing is really wrong. It's been defined as 50% in a feather. So in other words, if you believe that this woman, it's usually a woman, is telling the truth, 50% in a feather, if you think she's right, that she's telling the truth, then you expel this boy. And not only expel him, but he has a record of sexual assault on his permanent transcript, which it's protected, and you hear some people say it's FERPA, it's protected, that information doesn't get out there. Well, it gets out there if you try to go to another school, or if you try to go into any institution of higher learning, or if you try to be a doctor, a lawyer. There are very, very thorough background checks. And if I had a Title IX accusation on my record when I went through my character and fitness exam to be an attorney, I would not be an attorney right now. So it has a very, very long-lasting effect.
Right, and the problem here is that there are cases, unfortunately, where girls falsely accuse boys in college of sexual assault. There are cases where it's a drunken incident, they both regret it. And it's doubly a shame because people who do falsely accuse dilute the reality. It's like crying wolf, and it makes people pay less attention to when this really happens, which again victimizes victims of sexual abuse. But the point is, there's no recourse for these boys who are accused of sexual assault. They don't have any way to defend themselves. So this could be on their records, but they don't have any right to cross-examine witnesses. In some cases, they don't have any right to introduce evidence of their own. They don't have a right to legal representation. I mean, they are deprived essentially of due process of law.
Well, they're completely deprived of it, and that is changing now with the rescinding of the 2011 Dear Colleague letter. That is going to change, and there's some interim measures in place. But you're right, it is horrible. There's no due process. Everyone that I represent a lot of accused males. And none of them, and I don't just say it because I represent them, but none of them have done what they've been accused of doing. The girls have all lied. And, you would hate to think that women lie about these things, but they absolutely do. And every time there's a false accusation, it takes the women's movement back 50 years. Because now, even I, as a woman, every time I hear about something on the news, a man being accused, I immediately go, well, I don't know what the whole story is because it's probably not true. And that's a horrible place for me to be in as a woman. And it's because I see it so often.
Right. It is a shame. Like I said, it's a shame, especially for women who are actual victims, because no one wants to not be believed, and we shouldn't disbelieve people who are actual victims, and these other girls who are falsely accusing ruin it for them. Talk to me about these interim measures, though. So liberals are creating this hissy fit about Betsy DeVos rescinding those guidelines and issuing some new, you call them interim measures. What are they exactly? How are they going to protect both the victims and those accused?
Well, and they're interim. And I'm not completely happy with all of them right now because they're kind of a middle of the road thing. But one thing that they're doing, they're letting the colleges themselves decide whether or not they're going to use the preponderance of the evidence, the 50 and a feather, or the higher, clear and convincing, the 70%. And that's what most colleges were using before 2011. So I'm hoping that a lot of them go back to that. They are going to let you have an attorney. Shocking. No, you weren't allowed to have an attorney in these institutions. And I represent students, so I'm a little bit like the Wizard of Oz behind the curtain, pulling change, meeting with people, and kind of preparing them for interviews. But I don't actually get to sit in a hearing and ask questions for my client. If you saw the way these interviews go, the student has to ask a question to a tribunal. The tribunal then asks the witness, and then the witness answers the tribunal, and it goes back. It's so archaic. It's like something out of a Saturday Night Live skit. It's ridiculous. That's one of the right to a counsel and the standard of evidence is going to change. They are also not doing one size fits all, which is very, very good news. They're supposed to take each case on an individual basis and look at what's going to happen. What are the repercussions for each student in this? There are also going to be interim, and they call them interim measures, while you're waiting for the hearing. Usually there's a no contact order. They're going to make sure that it goes both ways, that if there's a no contact order, it goes for the male student and the female student. And I say that, I've had some homosexual cases, so it's not always male and female.
No. In fact, there was a case, and I want to bring this up. I think it was at Amherst College. There was a male student who was expelled. He was in a homosexual relationship. He was expelled, and he was the one who was raped. It was absolutely a deplorable circumstances. He was deprived of due process, and his life not only was ruined by being raped, it was doubly ruined because his reputation was smeared. Michelle, last question. We're almost out of time here. I do appreciate your point, or the point that you made about the unconstitutionality of being deprived of an attorney. That is a basic constitutional right. College campuses don't have a right to suspend that just because it fits their agenda. But when we're talking about the larger picture, not just college campuses, clearly the way that President Obama's administration interpreted Title IX, the Dear Colleague letter that you mentioned, it did not work. So why are liberals in general, liberal politicians, even liberal voters, why are they opposed to changing this if they don't have the same interests that the college does?
The only thing I can think is that they are willfully ignorant of the way that Title IX really worked in practice on the college campuses, because no sane, reasonable person would look at the way this was played out and think it was good. It was obviously wrong. No matter what side you're on, it was wrong. And I mean, rape is bad. And if you are raped, you need to have due process. But this is not fair for either side. It was really, really bad for both sides going into this.
Right. No, it was creating more victims, not protecting victims and exacting justice against people who committed the crimes. Michelle, I appreciate you coming on the show. Thanks for being here.